Hi, this is Attorney Mike Grevin coming here from Chicago, and today we're going to look at another horrible deposition. On the upside, it is funny. Before I unpack this debacle, I think I'm going to need a cup of coffee. Let's run over here real quick. Okay, the setup for this is that there's a deposition. It looks like we have two witnesses that get deposed here. Neither one of them says anything. One of the attorneys is very obstructionist, and the other does not know how to handle it. If you stick around, I'll tell you how you should handle it, and probably the likely outcome of what occurred after this deposition.
Thanks for telling me the questions I should ask. Will have your opportunity at the end.
Just shut up and move on with your questions, okay?
Mr. Curry.
Just shut up, or I'll adjourn this deposition, and you can tell it to the judge, or I'll get you some tissues and you can cry.
Mr. Curry.
All right?
Please don't tell me what to do.
You asked him if he ever spoke with Farsh about anything. He said no. Now you're asking him to tell you what Farsh told him.
All right, this guy is already off the rails, but assuming his characterization is correct, it is a inappropriate question. If you asked, did you have a conversation with someone, they say no, and then you say, well, what did they say? I'd object to it too.
It is a bullshit question. It is absolutely speculative, no foundation, or anything else. Now, he's entitled to a fair question. You told him that. So if you're going to sit there and ask unfair questions, I'm going to correct them. So I don't waste this guy's time having to come back or go to trial and undo the mess that you're trying to create. Got me?
Are you finished?
Are you finished?
Are you
Do
aware?
you understand the question,
Are
Mr.
you aware
Sheffer?
of the local rules
Mr.
with
Foster?
regard to what objections you're allowed to make and what
Do
you're
you
not?
understand the question, Mr. Foster?
Sir, right now this is my witness. I get to ask the questions. You get to make objections only. There are two types of
Call the
objections
bailiff.
you can make. Objections
Call
to
the
form.
bailiff.
I don't get this call the bailiff stuff. The judge is the one who makes the calls on these things. The bailiff is like a police officer in a courtroom. It might be different where they're practicing. I don't know where this deposition is taking place, but you're never going to hear in Illinois and Chicago where I practice someone saying call the bailiff.
Sir.
Do you understand the question being asked, Mr.
Mr.
Foster?
Curry,
Don't ever presume that you get to tell me what to do or when to do it, counsel. Don't you ever presume.
Why
Mr.
should
Foster,
you be
this is
entitled-
your deposition. Do you understand the question?
why should you be entitled to then tell me what to do? Doesn't it go both ways?
Because I'm being straight with the guy and you're being not straight with the guy. That's why. He has no dog in this fight.
Are you finished giving your opinions now about
He
the
has no
question?
dog in this fight, and you're trying to get him to say things that are simply untrue. It's an old trick, Mr. Zohar.
You don't think you're
Okay.
trying to coach the witness right now?
Oh, he's coaching the witness, all right.
I'm telling him what the question is so he can answer it.
Do you know what speaking objections are?
Don't lecture me, idiot. I'm telling you I'm not gonna let that happen. Okay?
I'm torn on this one. The objections are ridiculous. In a discovery deposition, you can ask whatever you want, pretty much, and they should be answering the questions. But the way he tries to lecture him is really annoying as well.
You got me? Do
I
we
wanna
understand
know
each other?
if you understand the
Are we
rules.
connecting here? Because
I'm
if we're not
trying to
connecting
proceed.
here, I will try again. Okay? Don't give me local rules, don't give me procedures, don't give me professionalism. Just put a fair question to the witness. And if you're not going to do that, then I am. We understand each other?
If you believe that a question that I ask is not proper, then you get to pose a valid objection. You're not allowed to make speaking objections. You're not allowed to give your
Don't lecture me,
opinions.
puppy. Don't lecture me. I was doing this when you were still chasing cheerleaders. Don't you even think about lecturing me about depositions.
I think you're practicing a few
So-
years more than me, actually.
so-
That's it,
so-
to be honest with you.
Do you understand the question?
Mr. Curry,
Let's have the question read
it is
back,
my
please.
desire to follow the rules. If you don't believe we should be following the rules, then maybe you need to explain to me what procedure we are supposed to follow.
Now, do you think that there's anything wrong with adding Testmaster students who you met only by virtue of your employment at Testmasters to a prospective client file for your competing company?
Would you read the question back, please?
Now, do you think that there's anything wrong with adding testmaster students who met only by virtue of your employment at testmasters to a prospective client file for your competing company?
Object to the question. There's no foundation. It calls for speculation. Seeks a legal conclusion. It's argumentative, and I'm instructing the witness not to answer.
Mr. Tatey, do you think that it would be improper for you to copy your employer's course material while you're a testmaster's instructor and use it for a competing business?
Same objections, same instruction.
So as we sit here today, you don't know whether or not it's a true statement that as of March 30th, 2005, Blueprint had not yet finished the writing and production of its LSAT course.
Objection, argumentative, also invades the attorney-client privilege and the work product doctrine. Instructed not to answer.
Do you deny, Mr. Tatey, that as of January 12th of 2005, that Matt Riley was a Blueprint partner?
Objection, same objections, same instruction.
Okay, there's a procedure for handling this. If you ask a question and you're not getting an answer, what you do is you ask the witness, are you not answering this based on the advice of your counsel? And if they say yes, then you say, okay, I would like to certify the question. Then you get to take it in front of a judge and get a ruling on whether or not that question should have been answered.
Mr. Curry, this goes to the very heart of the case here, and I'd ask you to reconsider your instruction and allow Mr. Tatey to answer this very simple fundamental question.
I've reconsidered. The answer is no.
That is my favorite part. It is just delicious. The guy's obstructing. He's not playing by the rules. He hasn't all day. He's not going to reconsider. You don't ask your opponent to reconsider. They don't even have the right to rule on it. You certify the question, you take it to a judge.
Can you rule out the possibility that Matthew Riley was a Blueprint partner while he was still teaching for testmasters?
Same objection, same instruction.
Do you deny that Matthew Riley was a Blueprint partner at the same time that he was teaching testmasters classes?
Same objection, same instruction.
Do you deny that Matt Riley was working on the Blueprint website while he was still teaching classes for testmasters?
Objection, it's argumentative. Calls for speculation. There's no foundation. Instruct the witness not to answer.
And can you say with certainty that Mr. McCarthy did not help in any way in helping Blueprint create the course material?
Objection, calls for speculation. No foundation. It's argumentative. Instruct the witness not to answer.
Do you deny that Courtney Martin was working for Blueprint on its website while she was a testmasters instructor?
Objection. Same objection, same instruction.
Were you trying to get Courtney Martin to do work for Blueprint while she was a testmasters employee?
Objection, vague and ambiguous. You can answer if you understand the question.
I don't believe that I was.
Do you deny that you were?
Objection, asked and answered. Argumentative, no foundation, calls for speculation. Instruct the witness not to answer.
Now, why around this time period did you want to damage Robin Singh?
Okay, in my mind, this is the first valid objection in about 5 minutes. He starts with the premise that you're trying to damage somebody else. It's a bad characterization. It might be so, but that's not the way you ask a question.
Objection, calls for speculation, no foundation. It's argumentative. Instruct him not to answer as phrased. Okay, that's it.
Well,
Thank you.
let me.
No, we're done.
Okay, that's fine. I'm not asking any more questions. I want to make a record here, if I may, Mr. Curry. I think that your instructions not to answer numerous questions are improper and unfortunate, particularly in light of these new documents that were just discovered. The judges repeatedly suggested that we should. There's a likelihood of having follow-on discovery after e-discovery. I think that it's improper, and I think that you're obstructing our ability to get to the bottom of these critical and highly damaging documents. And I'd like to put you on notice that if you don't allow us to continue to ask questions now or at a subsequent time, that we believe that you will be obstructing the our ability to obtain evidence about improper discovery abuses by your client, and that you will be aiding and abetting in those discovery abuses. And I ask you to reconsider and permit us to ask Mr. Tatey these questions.
Take your threats and put them where you know better.
I'm not making
We're done.
threats.
Yes, you
Mr.
are. Just tell it to this. Somebody who cares. See you Wednesday. Same step and my usual orders. Thank you.
Like your work, Mr. Curry? Like your work? Like your work, Mr. Curry?
Well, that was a complete debacle. Of course, it was funny because the one attorney was just completely out of line, but neither one of them handled it well in this particular circumstance, the way I see it. The first guy's making objections that you really probably can't make in a discovery deposition, at least 90% of them. And then the second guy is pretending that he's got a judge there that can rule on these issues, and or that the other guy cares. The other guy doesn't care. You just make a record and get it in front of the judge. You certify the questions that you want, and you take your record to the judge. The most likely outcome here is that the judge made them do the deposition again. The obstructing attorney may have even gotten sanctioned for this because he's just directing them not to do that. See, so a sanction might be, for instance, they might have to pay for the time or the court reporter or to redepose that, or they could actually just put a penalty or a fine on top of it. But he does finally get to arrive at that conclusion at the end of the deposition. It sort of just says that. But it's been a pet peeve of mine for years, of people who want to argue on the record. Just make a record. There's no judge there. The judge isn't going to see it till later. Just make a record of what it is that you're going to complain about later and move on. Do not pretend like you're going to come to some agreement with somebody who's that obstructionist. It isn't going to happen. But it was kind of fun. Like I said in my last bad deposition video, most depositions don't go that way, but some of them do, and I've been to many depositions like this. Usually they're not. They're usually much more civilized, but if someone gets into a groove like that, it can get real chippy, and that's what happens. So if you like that, please hit like and subscribe and ring the bell. Here at Law Talk, we do a lot of videos answering common legal questions. We also do reviews of law in the movies and then on TV. We also share some of our more interesting cases. We're always putting out new videos. So if you like that, please hit like, subscribe, and ring the bell.